you are awaiting, or if we are to await the whatever Parliament chooses to do, if it chooses to pass an act, surely this is necessary in the facts and circumstances. Why should they be encashing and commercially using WhatsApp data for their business model and their business profits at this stage? This is my request. We have placed that priority, and a reminder pops up every time you open WhatsApp, or almost on a daily or weekly basis. On a daily basis, that please agree. So they haven't discontinued it. Just let me summarize what is here and what the current position is. The original policy, not policy as in the privacy policy, the company's business policy was either you use WhatsApp, either you adhere to this new policy of ours, or we are discontinuing you from using WhatsApp. That was their original position. And then messages were sent to WhatsApp users saying agree to the new or opt out. On that element, there has been a change. What is the change? They have said that we are not going to throw you out if you don't adhere to it. However, they keep sending a message to those who haven't adhered to the new WhatsApp policy, and a reminder pops up every time you open WhatsApp, or almost on a daily or weekly basis. On a daily basis, that please agree. So they haven't discontinued it, but they have brought in the WhatsApp policy. So now I'm making 2 points. The first point, with broad points, and then I'll come into the details. The first broad point I'm making is that WhatsApp found itself in a similar situation with regard to the General Data Protection Regulations of Europe, GDPR. So the situation they found in GDPR was that GDPR was on the anvil, or GDPR had come, but it came into force after, say, for a term of 2 years, because companies were given that lead period. At that point of time, they gave an undertaking even before GDPR had come into force, and they said that we will not prejudice in terms of sharing WhatsApp data with with Facebook. So please keep that in mind. So that is one request that I am making, because this is in terms of their European policy, they have expressly said so. They are not saying so insofar as India is concerned. So if they want the advantage of, let us have the advantage of a new act, etc., which comes into force, until that act comes into force, in our respectful submission, they ought to give such an undertaking, or the government of India takes appropriate steps and requires them to ensure that there is no such data transfer. That's first point. I'll develop it. Second point which I want to make is that the government of India itself has filed affidavits in challenges to the 2021 policy, and said that this is a sleight of hand which you are taking against WhatsApp, and saying that the manner in which you are imposing this and telling users that either you drop out or you adhere is completely impermissible and violates the right to privacy. That's the government of India stand on affidavit in certain challenges which are pending. That's the second point. The third point which I will make is, I will take you through some of the clauses which are there insofar as the European requirement is concerned, and which are not there insofar as India is concerned. So on these 3 planks, I'm going to make a request for these prayers. Now, please go immediately in this same application to page 23. Page 23. Now, here, I'm going to just very quickly...
Have they filed the counter in this, actually?
Yes, they filed it after notice. Correct. So I just quickly now indicate what they are telling European users. So I'll read it out from their own 2021 policy, which is absent in the India policy. I believe all of this is helpful, is wholesome and desirable, and ought to be the subject matter of the interlocutory order until whatever the Constitution bench then considers the case. Now, in first point I wish to make is that you have now seen, so there's nothing further to say, that there is a dramatic difference between the policy being applied in certain jurisdictions and the policy being applied in India. I've made that point over here. I've also flagged the issues that each one of these particular elements of consultation, right to object, consultation in the sense that you have an option to opt out, etc., are all wholesome and completely consistent with privacy rights. One. The second point I want to make is with reference to page 163. And this point is that they gave, when the GDPR was still in the anvil and had not come into force, the undertaking which they gave, the European regulators, was that, look, we will not share our data with Facebook entity. That's very important for me. Now, it's up for the court to make a call, but just go to page 163. This is their undertaking there. I've read out my prayer already. Please see para 17. In order to provide, page 163, in order to provide reassurance to public concerning any future sharing of data between WhatsApp and any company of the Facebook group on a controller-to-controller basis, WhatsApp Inc. and WhatsApp Ireland both give the following voluntary public commitment. A. WhatsApp will not transfer any WhatsApp EU user data, including the UK users, to any other Facebook company on a controller-to-controller basis for any purpose prior to the General Data Protection Regulation GDPR coming into force in 25th May 2018. WhatsApp will only commence the sharing of WhatsApp EU user data with any other Facebook company for safety and security purposes. Sorry.
EU means what?
European Union. So this was before European Union comes into force, the GDPR comes into force.
What have they given the undertaking?
They have given an undertaking that WhatsApp would not share data of WhatsApp users with Facebook, except for the security and other purposes, which are safety and security purposes. So what we are suggesting to the court, since it was mentioned that, look, we have still to have on the anvil, the act is to come, we'll have the advantage of a new law, etc., etc. Then surely, until the new law comes into force, just as in the case of European users, they said, we are not transferring data to Facebook and Facebook entities. So the question is, if you are awaiting, or if we are to await the, whatever Parliament chooses to do, if it chooses to pass an act, surely this is necessary in the facts and circumstances. Why should they be encashing and commercially using WhatsApp data for their business model and their business profits at this stage? This is my request. We have placed that prayer. I'm very grateful.